party there. So
thank you, Professor. In fact, I'm not taking much time, but I just want to say at the beginning, rather than discussing about human rights violations and public interest litigations, today we have seen some progressive thoughts of Professor and the Professor Kamal, because why we are concerning about public interest litigations and human rights violations. Can the present system totally eradicate these kind of violations, and the reasons which we are compelled to file public interest litigation? That's the main issue. At the outset, I must say, in 1970s, the capitalist countries, they realized the fact that the imperialism cannot move forward because the situation of the world had been drastically changed, and they want a new method to impose these imperialist ideas to other countries, especially Margaret Thatcher and Ronald Reagan. They have realized the fact that they cannot move forward. Their capitalist theories cannot move forward. As a result of that, they introduce new methods. We are calling that neoliberalism. So under neoliberalism, their main concern how to sell their products, how to make markets to sell the excessive production of these countries. So in order to do so, they needed new theory, new concept. We are calling that neoliberal system. In 1970s, Indira Gandhi, without much resistance, she introduced these reforms to India, and simultaneously in Sri Lanka, Mr. J.R. Jayawardenna, they introduced these neoliberal reforms to Sri Lanka. As a result of that, the government has to facilitate multinational companies and the other people who are willing to sell their excessive production to the general public. So that is the main problem now we are facing for. I will quickly go through some examples. In India, actually we have to thank India because they have developed this public interest litigation. Justice Bhagavati and other judges, their directions and their orders directly influence the Sri Lankan judiciary also. Now, as I said earlier, now to move forward these neoliberal reforms, the government should sell the education, and they should spoil the water. They should violate the rights of the clean air and the clean water of the people. So without violating these rights, these governments cannot move forward under neoliberal system. For example, it is very important to analyze the fact that when we study in the public interest litigation, we can see two aspects. The one aspect is, due to public interest litigation, the awareness of the people and the actively participation of the NGOs and other progressive people, we can see by way of public interest litigation. The other thing is, if we are analyzing the public interest litigation, we can understand the crisis of the system also. For example, I can say in Subhash Kumar case in India, the right of water and air was discussed by the court. And another very important case, that is Mohini Jain case. In that case, right to education was discussed. And the Telis was Bombay Municipal Council. In that case, the Indian court discussed about the dwellers. And the Pakshim Banga case, the health rights of the people have been discussed. And the Asian Game case, the Indian Supreme Court discussed about the labor rights. So having analyzed all these things, the privatization of the education, the violation of the water rights and air rights of the people, and regarding the spoil the environment and the privatization of the health, all these issues were discussed. So when we are analyzing all these public interest litigation, we can understand the crisis of the neoliberal system, because the neoliberalism is always trying to violate the rights of the people, and they are going to privatize the health rights of the people, they are going to violate the education rights of the people. So in that sense, the by way of public interest litigation, we can challenge the system while standing in the system. So therefore the India have given these kind of examples, especially to understand us the crisis of the system and how to challenge the system within the framework of the neoliberal system. When I come to Sri Lanka, it is I have to say, both lawyers and judges have less concern about the public interest litigation, because there are some myths regarding the public interest litigation, because they are arguing that the public interest litigation is not a part of the law of our country. And the second thing, their main argument is public interest litigation cannot be litigated successfully in Sri Lanka. So those myths were there. But there are some few cases we can discuss in similar to India, because the right to life we have discussed earlier. In Sri Lanka also there was a famous case, Shreyani Silva case. In that case, the court recognized the ideas of the Justice Bhagavati and others regarding the right to life. Although the right to life is not in the constitution directly, according to this judgment, it says the right to life is contained in our constitution. And another very famous case in Sri Lanka, that is we are calling the Eppavala phosphate case. There is a phosphate rock in the Eppavala area. So the government entered into an agreement with a private company to sell that rock. You can see the consequences of the neoliberalism. Without concerning about the people's right, they sold this phosphate rock by way of agreement. Then the people came before court and challenged that. The court held that that agreement is totally wrong, because they have not concerned about the rights of the people who are resident in that area. And there's another important case, we are saying that water sedge case. The government entered into an agreement with a private company. That area was acquired by the government for the public purpose of water retention, but subsequently they have transferred that to a private company to build a 5-star hotel. Ultimately, people went to court, and court held that that agreement in laminate is fraudulent and illegal agreement. So these kind of experience we can see in Sri Lanka, but still, as far as the public interest litigations are concerned, we are failed. I will give few examples. For example, in Valivaria, there was an incident, latest incident. Due to a particular company, particular factory, the water was totally polluted. The pH rate of the water reduced to 3.5. Thereafter, people made lot of the people filed a case regarding that, but court refused that case. Subsequently, they came to streets and they fought against in respect of for their water rights. Subsequently, what the government did, without taking the part of the people, the army intervened, and the 3 people were dead due to the incident, the general public. So the government had not any concern about the water rights of the people. Same kind of incident happened in Meetormulla. The municipal council is dumping 800 tons of garbage to that area, and due to that their rights were violated, but government intervened that, and they took the part of the municipal council. They did not stand with the people. And as far as the labor right concerned, there was a struggle of the laborers in Katunaik area, because the government take over their labor funds to the government to stabilize the government funds. In that occasion, the laborers came to roads, and again the government attacked them, and the government violated the rights of these laborers. So in all these incidents, the interference of the court is not cannot be justified, because court always stand with the government, and the very concept of the public interest litigation was failed in all these incidents. So what I have to say is, we have to thank the Indian judiciary and Indian judges, because they have developed this public interest litigation. As a result of that, the Sri Lankan judges and Sri Lankan lawyers also compelled to practice these public interest litigations, and they came forward representing the rights of the people. However, in a nutshell, I have to say, under the neoliberal system, it is very difficult to protect the rights of the people because their main concern is the market. So, at the same time, while fighting against these right violations, at the same time, we have to stand this change. We have to think about the change this system also, because now I have a lot of experience. Almost all the conferences, seminars, they are teaching us to how to protect the system. Then in the system there are some various ways to justify the system. Human rights also like that. If there are courts, you can go courts. If there is a violation of right, you can go court. You need not to change the system. That is the nature of these, most of the conferences and the seminars. But the thing is, we are not teach about the very reason of all these crises, all these incidents. So, according to my thinking, what I have to say, there is a system failure and there is a crisis of the system. Without changing the system, we cannot think about a world without having crisis, without having human rights violation. So, until we are doing that, again and again, we have talked about public interest litigations and human rights violations. Therefore, at the same time fighting within the framework of the system, as youth of the world, we have to think about the new system also. Thank you very much.